So, Shawn, thank you for joining me this morning.
Not a problem, Corey.
I wanted to bring you on because we do a little segment called Mind My Business. And basically what that is it's an opportunity for you, a business owner or proprietor or what have you, to explain to everyone some of the ins and outs, the whys, and I think more importantly, give some information on how they should choose an individual in your field. So maybe we start with what your field is, how you got into it, and we don't have to go back as far as 8th grade when you envisioned that this is what you would be as an adult, but maybe start towards the beginning of where you think.
I don't know if you go back to 8th grade, I probably wanted to be a rocket scientist. So you're right, we probably don't want to go back that far.
Yeah.
So the first thought I had about what I do, which is estate planning, that's my primary business, along with elder law, and primarily I do long-term care planning, which means we help families protect themselves against things like catastrophic healthcare events or long-term care in a nursing home.
Okay.
So those are the two biggest pieces of what we do. We also do probates and trust administrations, which would be kind of the cleanup on aisle 3 if someone passes away. And then we also do some value acceleration for businesses, which includes succession planning and estate planning for the business owner. So those are kind of the big pieces of what I do. There are other ancillary things we do that are related, but those are the big pieces.
Okay.
So the estate planning really goes back to when I started practicing law. I did what was called threshold law, which means anything that came in the door over the threshold, I would do it. And that meant traffic tickets, divorces, wills, trusts, whatever it was.
Is that a common term, or it seems like maybe a common place for lawyers to start in, right?
Oh, absolutely.
Because it's kind of just you're taking whatever you can.
Well, if you don't start with a big firm or even a medium-sized firm, you're going to do whatever you can to make money, to make sure your business grows. So that's what I did. And at the same time, I was working as an engineer at McDonnell Douglas. I actually worked for the government there. So I had to kind of do threshold law and still work full-time as an engineer. So that was kind of how I started out the process. Was just that threshold law piece of it. A friend of mine, after a couple of years, decided he wanted to get rid of his title company, which I thought, well, I love title companies. I think that'd be great. You know, you get going in the morning, make sure everything's ready to go, take off, go golfing, whatever you want to do, come back in the evening, collect checks, make sure everything gets signed properly, go home and have dinner and have fun.
So when you say titles, that encompasses...
So title insurance, think about it this way. Have you ever used a title company when you buy a house? Yes.
Yeah, or
the
a
answer
car.
is yes.
Yeah, or a car.
Well, no, it's different. So a title for a car is the evidence that you own it. The title company is the company that creates all the documents that you see at closing, including the deed. So it's kind of a little bit different. And then title insurance...
Would it be similar to an underwriter?
There are underwriters in the title insurance market.
Okay.
So when you buy title insurance, which is a guarantee that the property that you're passing from the grantor, in this case the person that's selling the property, to the grantee, the person that's buying the property, that it's a proper title, and that if there are any clouds in title, that the insurance policy would cover any sort of actions in court that are required to settle that title.
And do you work for the buyer or the seller in that situation? Or both? Generally,
you're going to work for the seller.
Okay.
Okay. So it's going to be on your sheet of closing items, right?
And I might dive a little deeper than what you're used to going, but I'm trying to layman it out.
Fine.
Really.
That's fine. Because I don't do any of that.
Yeah. Okay.
But you're going to look on your closing sheet, and you're going to see title insurance. You're going to see the title company itself. You're going to see all of your other closing costs. So those are generally negotiated, but generally the buyer or the seller is going to pay for it. And again, that's just part of the negotiation of that contract.
So
does that make sense?
In a nutshell, you'd be helping decrease the limits of liability or decrease the liability chances from what may not be included in that contract.
It's a little more complicated than that, but yeah, that's generally speaking what it is. You prepare all of the closing documents for the seller, and then you also prepare a title insurance policy.
Okay.
And that title insurance policy, that's where the real money is. is in issuing those title insurance policies.
Got it.
Okay?
Yep.
All right, cool. So Richard Boardman, he was my friend, he was going to sell me his title practice.
Yeah.
And he said, Shawn, I'm so excited about this. You should come and see what I'm going to do. So I think we went to Indiana. Pretty sure it was either Indiana or it was Denver. And I went to this thing called Collegium that was put on by a group called the National Network of Estate Planning Attorneys. And I sat there for 2.5 days learning about what a trust was, what an estate plan was, what the difference was, and how you make money in terms of marketing and legal technical with the estate planning practice. And so when it was all said and done, and Richard said, well, what do you think? I said, well, that's what I'm going to do. You're going to have to keep your title company because I'm signing up right away, and this is what I'm going to do. So I started right away with the National Network, found a friend who I'd gone to law school with, and over the course of the next year or so, we talked about starting a partnership and working this. And so around about late 1998, I left McDonnell Douglas at the time, and started working full-time with my partner. And that worked for about a year, and then I decided I needed to start making real money. So I went back and started working at Boeing, because Boeing had merged with McDonnell Douglas back in the day.
Yeah, my grandfather retired from McDonnell Douglas, I believe, in '93.
Yeah, so that was before all of the action started.
The mergers. And
the merger actually was kind of an acquisition.
Yeah.
Yeah, every time I saw a
borderline
contract,
hostile takeover.
Well, it wasn't that hostile. I think Boeing needed the cash flow from the military contracts, and so there was a lot of inside baseball I won't get into. But yeah, it was an interesting time. So that didn't work out, but I really tried to continue to practice law part-time, and connected up with another really amazing attorney, Thomas J. Ray Jr., who helped me learn more of the more complex estate planning. And in the interim, we went from the National Network to a group called Wealth Counsel, which I'm still a part of.
Okay.
And what they do is they provide all the really wonderful documentation that we use. They also have training.
And this is in the estate planning realm that we're
estate
talking
planning,
about now, right?
elder law, and a lot of the more complex estate planning areas, like for instance, charitable planning, or planning for the
like an in-kind donation of the estate.
It could be in kind, it could be cash. Oftentimes during your lifetime, you're going to give away stock or other property that has a low basis, because you don't want to have to pay
the penalties and fees,
income tax associated with that, because there's going to be a capital gains tax. So giving it away to a charity allows you to give money you would have otherwise given anyway and avoid a capital gains tax.
So it's a strategic way to move money around to
it can be
minimize your
losses. Minimize your losses. Yeah, because dealing with the tax guy is always going to be a loss. That's the one you can't really plan for.
It's funny because we started this whole country on a 2% increase, and now it just we're all obliterated with like 50% taxation.
Yes, welcome to the U.S. where you are properly represented. Yeah, and you still are getting toasted. Yeah. So that's where I'm at with Wealth Counsel. So, just kind of an overview. I started out really just with the what I call threshold law, which is anything that crossed the threshold of the door, and then progressed to estate planning part-time, and now I'm fully estate planning and have been since 2013.
Okay. Is elder law still part of this? And if so,
correct,
or if not so, what is elder law when you say that?
That's a great question. Elder law is a very broad spectrum of services we provide to families and individuals that are needing care above and beyond what you normally would expect in terms of health care. Okay. And it could also include people that have special needs that are not elderly. So, for instance, someone that's in their 20s.
Mental incapacity
or
physical
incapacity, something where they're not going to be able to manage their own care.
Okay.
One of the standards we use is that Social Security has defined what disability is. And when you have a disability and you have it prior to a certain age, the Social Security Administration will issue a letter to you explaining that you are disabled. Okay, and that disability will allow you to get certain benefits, like either Social Security, Supplemental Security Income (SSI), or Social Security Disability Income (SSDI). SSI comes for people that are otherwise disabled prior to their working age. Let's just use that instead of a number. And then if you've had work and you've worked during your lifetime and then you become disabled, then the SSDI becomes the benefit. Okay. So I'm not so much working with people that have SSDI, more the SSI for the special needs. Okay.
So on the DI side, would that include, and probably thereby why you don't work with that, a fireman who's injured on the job, or someone who's injured in a factory job or at work?
We just haven't reached the point where what we do, other than the estate planning side, where that makes sense. Now, there may be a day when that person that's on SSDI is going to need to prepare for long-term care benefits because that injury has continued to progress and become more problematic, and they're going to need more care. If that day comes and their other income and assets and insurance don't cover it, they may need Medicaid benefits.
Okay.
There are ways to plan for that ahead of time. And I don't want to get into that in too much detail right now. We can talk about it a little bit later, but I want you to understand conceptually that that person has to reach a point where long-term care, either at home or in a nursing home, is
maybe their only
necessary.
option. Yeah.
It may be the option they're drifting towards.
Okay.
Whereas with someone that has SSI, that is special needs, we're going to do potentially some planning right away. So we may either create what's called a testamentary special needs trust or supplemental needs trust, which means that on the passing of the parents of that person, we would create a supplemental needs trust that would allow the money to be used for their benefit, but at the same time, it wouldn't count towards their own income needs. So it wouldn't interfere with their federal or state needs-based aid. So our goal there is to make sure that that person can still get aid, but also has additional monies for extras, things like vacations or education or whatever is not covered by any of those other benefits.
Or they may have to have some sort of benefactor or overseer of some sorts, right?
Generally, it's going to be a trustee that's going to manage the healthcare side.
Okay.
There's going to be a guardian that's going to manage their
finances and housing.
Well, no, the guardian is really going to manage their healthcare, their person.
Okay.
The trustee is going to handle finances, and there may be somebody that's named as a conservator or whatever, again, for money that's theirs, that's not covered under the trust that the parents created. We can also create a trust during lifetime. Okay, we call them inter vivos, during lifetime. So that lifetime trust, it can be supplemental needs, and generally speaking, it's going to be one of two types. It's going to be first party trust, which is one where it's that incapacitated person's or disabled person's money. And generally speaking, that's going to be if the person for some reason won an award. Our friend James Avery wins an award for one of his clients. And it's a really large amount of money, but that person is now disabled. The court can order that that property be incorporated into a first party supplemental or special needs trust so that that property can be used by the trustee to help that person who's now receiving federal and state needs-based aid. But at the same time, eventually, that state and federal aid will be repaid by that trustee, and anything's left would go to the family. There's a third-party trust where...
So is that like a draw against that? Would it be, in other words, if I'm receiving, and I'm going to speak very hypothetically because I don't understand anything else, but if I'm receiving $1,500 a month in government care and assistance, yet my trust has been set up to where I receive $2,500 a month for 20 years. And when that overlaps, or when I am deceased, and there's a total of $10,000 I've received from the government, and I've still got 3 more years on this trust where I'm going to bring in an additional $25,000, does the government receive that $15,000 they paid into what my supplement was?
Here's what happens. So suppose we put $250,000 into this first party trust for the benefit of this person that was injured.
Okay.
Injured. That's a good word, isn't it?
Yeah, injured. It's a new one.
Injured, yeah.
We'll put it on Wikipedia.
Okay, we'll go for that. I have to tell Jim about that one. Hey, Jim, have you had any injuries lately?
Yeah.
So our goal here is to understand that that first party trust is not going to be counted in terms of income or assets for that special needs person.
Okay.
So they're going to still get the federal and state needs-based aid. When they die, and all of the distributions from this have occurred for that person, okay, and they were all legitimate, okay, so there were no impacts to that person's special needs benefits, then whatever's left, the government's going to go, okay, here's our bill. And they're going to go to the trustee and say, you are required under the terms of the trust to reimburse Medicaid, Social Security, whoever it might be. Okay, and here's what the bill is.
Man, they always get their money back, don't they?
They do, and that's the whole idea. The money should go back to them because they provided the benefit. So our goal is for that money to go back to the government. If anything's left, then it can be distributed in accordance with the remainder portion of the trust to family members or whoever it might be.
Okay.
Does that make sense?
As much as it can for
as much as it can.
Hearing it for the first time.
Little short time, and I don't have a board up in front of me to show it to you. So
I get the gist of it, and especially since I'm not in any part of that sort of situation on either end of it, then I think I have a very firm understanding of what that might mean. And certainly I would think that your description to anyone who is involved in this situation like that, whether they're the guarantor for this individual or the individual itself, probably has a firm understanding now of what you mean by those things.
I certainly hope so, but my goal is to help as many people understand what this means and how they can use that to benefit themselves and their family, and prevent all of their assets from being used up for the benefit of someone, so that it can be used for the benefit of the rest of the family. That's why we do this, is to protect the legacy of the family.
Do you have age, or do age requirements and restrictions come into play within your field as well as they do the financial fiduciary field? So I know that, if you have a Roth or you have certain things, at a certain age, 72 and a half, certain things start having to come out at a certain rate. Otherwise you're penalized, or you're not able to retrieve them at the same rate without paying a tax, right? Like if I want to take out my Roth early at 68, then I have to pay a 15% tax on that retrieval.
If you have a Roth IRA, if you take a distribution from it, remember that a Roth IRA is a post-tax retirement plan. So you've already paid tax on what's in there.
Okay.
And the deal with the Roth is that now any growth that you have, any gains, are also tax-free. So any distributions you take, whether it's at 59.5 or 68 or 72, doesn't matter.
So that includes the interest that may have accrued during that time period?
Absolutely. That's the beautiful thing about a Roth.
So what's the 72 and a half thing? Where does that come into play?
That's a required distribution. So it used to be 70.5. Now it's 72, and it's going up to, I believe, 75. But don't quote me because I'm not sure.
Sure.
What it means is that the government wants their money eventually. So they're going to tell you, especially with a traditional IRA, that you need to start taking required distributions so that they can tax that money that you have saved for your retirement.
Okay. So it's only taxed as it's paid out.
Correct. And what they do is they use what's called a lifetime distribution. So you use your life expectancy to decide how much money you take out on an annual basis.
Okay.
And I don't want to get into the calculation. It's based on the life expectancy of the individual who is a participant in the plan. But a Roth IRA is different in that, you may have to start taking distributions, but guess what? They're not going to be taxed. Okay. And then the other thing to think about is that's the person, that's the participant. If you are a non-participant, a non-spouse non-participant, okay, so a child or brother,
I was going to say it's like a dependent. It's like one of my children or something. Yeah.
Then if you receive that as an inheritor, then you have 10 years to take that full distribution from that traditional IRA. Same with a Roth. Got to take it all out.
At any rate?
No.
Or is there rate restrictions?
No rate restrictions.
So you could take it as a lump sum if you wanted.
You could take it day one. You could take it on the last day, or you could break it up in between. So that's why I ask people to think seriously about having a financial advisor if they've received an inherited IRA, because they want to make sure that their financial advisor and their tax professional take a look at that and make sure that there's not going to be an issue with their income taxes, because more than likely, when these people receive this benefit, they're going to potentially have to pay a relatively high income tax, because when do people receive IRAs from their parents? When they're in their highest earning years. So, for instance, mom and dad are in their 70s and 80s.
Right.
Well,
And
guess
we're in our
what? We're in our
40s.
50s and 60s and 40s, and we're making pretty good bucks, right?
Mm-hmm.
So that's when that's coming out. So you're going to get a double whammy of this IRA that has to come out over 10 years, right? Or you're going to have to pay the tax on your own money,
Okay.
right, that you're earning. So you've got that double tax whammy. If you're in that 40 to 60-year-old range when your parents die, leaving you as an inheritor of an IRA. So that's kind of an issue. And there are ways to resolve that, but they're a little bit out of the context of this conversation.
Sure.
Now, a thing to think about is that sometimes you can plan around some of that stuff. Again, we'll talk about that in a different context. But our goal would be to manage that IRA so that you make sure a spouse or someone that's otherwise not an exempt person, but a person that's not going to have to take it out over the 10-year period. Someone that's chronically ill, a spouse, a child under age 18, somebody has special needs. So if you got that special needs child, we can use that IRA over their life expectancy. So there's some ways to plan around that without playing around with insurance and things like that. But again, it's probably outside of the realm of what we want to talk about, but just understand there are ways to manage that.
Well, for me, I'm curious about how that might go if it's a 10-year period. Is there exemptions? Because let's pretend for a moment I only had one child. I have two. One's 20 and one's 9. If I were to pass tomorrow, my 9-year-old, even in 10 years, still wouldn't be necessarily ready to handle that distribution. And me as a single father, is there ways that I could set that up to protect that or keep that state in whole?
Yeah.
And you guys do that.
Yeah, there are ways to do that, and there are ways to make sure that it gets managed properly for that child, and make sure that there are no tax issues, income tax issues. Because recognize that if you have an IRA, traditional IRA, that's directed to or not owned by but is beneficiary, the IRA is benefited to a trust. Trust is the beneficiary. Is probably the proper way to put it. That distributions to that child through that trust, if they stay in trust, then they're taxed at the trust rate. So we want that child to have the tax at their rate, but we don't want to distribute it to that child. There are ways to manage that. Okay, and not every attorney does them. Very, very few probably do. But there are ways to manage that tax issue. Okay. So that minor child doesn't get those distributions. Okay. Right. But that again, the income that comes off of that required distribution at their life expectancy is taxed to the child, not to the trust. So those are two things to keep in mind. And it's a relatively sophisticated planning tool, but again, we like to do that for people just like you, where you have an IRA. We want our 9-year-old to be able to use it, but not abuse it. And then when they turn 21, we don't want them to continue to be able to use it, but not abuse it. And still, again, not have to pay the taxes at the trust rate, pay it at their rate, but keep the money in trust, keep that income in trust. Because once they turn 18, 19, 20 years old, I'm pretty sure they're still not ready for that kind of money.
Oh, no. I'd be no more prepared for $400,000 at 14 than I was at, really, honestly, 27, probably. And
I'm 63. You don't want to give me that kind of money.
Right, yeah.
Just saying.
I'd have ridiculous things and I'd be broke again in a year. But
fair enough.
So that's a portion of what you do.
That's a piece of it. We just really covered talking about elder law and the special needs side of it. Right. Okay. We didn't talk about the long-term care planning piece of it for older adults. So people like me in their 60s, sometimes even in your 50s, depending on your health, we want to start talking about the potential for catastrophic healthcare events that aren't covered by insurance. Okay. We want to make sure.
Could this include like Alzheimer's and the need for additional special care, or just as basic as a nursing facility in general?
Both. Right. And also, if you have, suppose you're in a car accident, and for some reason you now have bills that are just not manageable by insurance. You're not going to be eligible for Medicaid at this point. You don't have Medicare because you're too young, and your personal insurance doesn't cover it. You can wipe you out financially.
Yeah.
So our goal is to think about whether that's an issue for the client. Just to kind of take a step back, think about doctors and lawyers and captains of industry. They all know that there is a potential for litigation. Okay, so that potential for litigation is something that they plan for. And part of the way we plan for that is to set aside money in an irrevocable trust that's asset protected, another new word, asset protected.
Asset protection.
So that person can then manage that property, benefit from it, but then an outside interlocutor.
These are insurable liabilities. So when we talk about doctors and lawyers, just for everybody else
they're insurable,
watching.
But what happens if the liability exceeds the insurance?
Mm-hmm.
That's what we're talking about. We insure first,
right.
and then we talk about protecting the assets. And we can protect the assets both against creditors, predators, in-laws, and outlaws, and also if we need to, for tax purposes, for federal estate tax and state estate tax purposes.
But they have separate things set up for malpractice or whatnot, right?
Correct.
But you're going to come in and help say that this goes outside the bounds.
Right. This is supplemental planning.
How do I not get my house taken away as a doctor if I'm a pediatrician or a specialist and I get sued on the outside of my insurance?
Or my retirement plan or this insurance that I just spent years
Would this include things like a divorce too?
Mm-hmm.
Could it?
Absolutely.
Yeah. Okay.
We just have to pick the right state in which to put our trust.
Got it.
Okay, so there are a lot of moving parts when we talk about things like that.
Sure,
so I want to simplify it and just say, let's put money aside in a bucket just in case bad things happen, because we know bad things happen to good people.
Yeah.
So we have to recognize that money that we set aside isn't ours anymore. We're going to trust somebody else to manage it for us and make sure we're taken care of. Okay, so that is our goal. So we have to think about what is the risk? What is the risk of a catastrophic healthcare event?
Yeah.
What's the risk of needing long-term care in a nursing home or at home?
When you say risk, are you talking about calculated percentage of the odds that this may happen? Or
I don't
just
think it's,
if and when, how would I be prepared?
It's not that technical. Okay. Really, it's like, is this something I'm thinking about? Is this something that my family's gone through? I had two grandparents that went through a nursing home. My dad was in a nursing home. My mom was in a nursing home. They weren't there for very long, but it was really, really expensive.
Sure. Yeah.
I have clients that have been in nursing homes for decades. Okay. And their money just dried up. And at the end of the day, their family gets nothing.
Right.
I had a friend, John, who came in, I think it was in February, and he asked me to help him with some veterans benefits. I really couldn't do it at the time because we weren't doing veterans benefits and veterans applications at that time.
And that was something I was going to ask you about. I'm glad you brought this up.
Yeah.
Because does disability fall into the same category in that sense or no?
Yeah. So veterans disability is different than what I'm talking about.
Yeah.
There's a thing called veterans aid and attendance.
Mm-hmm.
It's supplemental income for a veteran or spouse of a veteran or a child that might qualify.
Okay.
Okay.
So it's very specific to that field.
Specific to that type of care. Okay. So just think of it that way. Now there's an application you can put in, but it's better for most families if they go to a veterans organization and have that organization prepare that.
Mm-hmm. Okay.
Now if there's some planning involved, if we're trying to manage the planning side of it and set aside assets, that's where we come in. Okay, right. So John came in thinking, hey, Shawn, can you help me out? So I asked him, where are you guys at? He said, well, we're at $135,000, which is right in the zone where you start being able to apply for veterans aid and attendance for a family member of the veteran.
$135,000 in yearly costs?
It's a combination of income and assets. So if your income and assets are
equal that amount,
are under, and I think it's $138,000 right now, but again, that's a number I look up. I don't try and memorize it.
Sure. But there is a threshold of some kind.
There's a threshold of income and assets, and you calculate it, and you figure it out, and there it is. Okay. So that's your threshold. He was at the threshold. And so he asked me if I could do that. I said, John, we're not doing just the application. We generally do the planning. Mm-hmm. And then if the application is part of the planning, we can certainly do that. But at this point, that's not part of what we do. But explain to me what happened with your mom. How long has she been in the nursing home? Oh, she's been there 9.5 years. I said, gee, how much did she start with? About $1 million. So she started 9 years ago with $1 million, and she's down to $135,000.
Yeah.
John, had you come in 3 or 4 or 5 years ago, we could have set aside some of that money in trust. You could have applied for the veterans benefits much earlier and still had money left over to make sure she's taken care of at the nursing home.
Yeah.
And also because you and your wife really would need this money at some point, it would have been there for you too.
And are you dividing up deliverables as well? Because I know that, so we were fortunate enough to where one of my family members is well-versed in financial planning, but my grandmother, who will be 92 years old, still sharp as a tack, mobility is a little different than it was, but just amazing. She had bonds and some other things that totaled a certain amount of money. Those couldn't be issued to her. They had to be gifted away in order for her to receive the Medicare or Medicaid, whichever assists, whatever assists in paying for the assisted living retirement village, not retirement home. We don't call it that. She doesn't like when we call it. So she has an independent apartment. It is a community. She has her own apartment. She does things. She doesn't, really have assistance. But we had to deflect that because it was part of an asset that would go against what she was able to receive from the government.
Okay, so she probably
makes more sense to you than me.
Yeah, so she's probably not in a position right now where she's receiving any sort of Medicaid benefits. If she's in independent living, she's fine.
Yeah, because she hasn't run out of funding.
She's got her own money that she's using.
Yeah.
But what they probably did was took part of what she has, part of her assets, and said, okay, we really definitely want to hold on to this. We want to make sure that this is set aside. So for veterans benefits, we set it aside 3 years before we need to apply for the veterans benefits.
Okay. And my grandfather was retired Navy.
Right.
And also retired McDonnell Douglas.
Right.
So what she was receiving as a non-working mother was basically his pension and his benefits.
Yeah.
Yeah.
So she's using that for her current care, plus other assets that she decided to keep in her hands.
Right.
Everything else she's put over into a asset protection trust. And she can apply for veterans benefits 3 years after the gift. And then if she needs Medicaid benefits, she can apply for that 5 years after she's made the gift.
Okay.
Okay. If she can, right?
Yeah.
There may be a point where she has to apply sooner, but that's okay. As long as you continue to private pay, okay, you get past that 5-year look back period that everybody has heard about, but doesn't understand. And then you apply for those Medicaid benefits. And then you have set aside that money for the extras. And then if you pass, that money goes to your family, not to the nursing home. So the way I ask my clients about this is, do you want to write a check to your family or to the nursing home? If you want to write it to your family, we'll put it into this trust and we can apply for veterans and Medicaid benefits sooner. Or you can just keep it and write the checks to the nursing home over the course of the next 5 to 10 years, however long it takes. And so you just have to ask that question. And generally the answer is, oh, I would prefer to give it to my family.
Sure.
On occasion, though, the family isn't quite the right person. They're not trustworthy. They're going to use the money for themselves. Because guess what? You are giving that money away. It's not yours anymore. So you got to make sure you trust the people that are managing it, the trustees, and the people that are the lifetime beneficiaries, sometimes family members.
So we've talked a lot about scenarios, situations, and estates for elderly. And is it a coincidence that that's called elder law? I mean, that's not really.
That's not a coincidence.
So when should an individual begin looking at this sort of estate planning or preparation? I'm 40 years old. Do I wait until I'm 60? Should I speak to someone now about it?
What you should do right now is talk to our friend down the hall,
Okay.
Jeff, and see if he has some long-term care insurance that you could use just in case something strange happens. Because you're 40,
Right.
it's going to be a lower cost, okay? And you can get some really good long-term care policies at a relatively low cost at your age, okay? So we insure first. Same with life insurance. Life insurance first, okay? And then we talk about protecting you. When is the right time to start protecting you? Okay, do you want to protect yourself against divorce and other bad things happening to you? Then we talk about lifetime planning for asset protection. Somebody want to take your business from you, all that success. We can do that. as you get closer to your 60s, unless you have some sort of a chronic illness or something like that starting earlier, we don't start talking about long-term care planning until, again, 50s or 60s, again, depending on your health. We may go into your 70s because your health just doesn't say, hey, scream, let's plan.
Well, does high risk health, not necessarily long term, because the reason I ask this is I've had heart surgery when I was born, right? I was born with 2 holes in my heart. I've had 2 heart attacks already.
Okay.
And 2 to 3 anginas, which is like a minor heart attack.
Right.
Prior to being 20 years old, I went to Cardinal Glennon still for my checkups up until 21 because that was my children's hospital where I had my surgery. And the expectation was then that I would have major heart failure before I was 25. I don't know that I need to look into long-term care, but should I be looking into emergency estate planning or something like start with my health insurance, life insurance, got that.
Right.
But when do you come into play of that, or do you?
Generally, I do, and the 2 scenarios are incapacity. So in your situation, what's the likelihood you're going to have an embolism or something as a result of some of these cardiac issues?
Yeah.
I don't know, not a doctor. What's the likelihood that you're going to become incapacitated and unable to work as a result of that condition? Don't know, but those are all risks to take a look at.
Okay.
What would probably more than likely happen is that if you became unable to work, you would receive that Social Security Disability Income, SSDI. Okay, so that's something that you would be able to hang your hat on if you needed to.
Now, do you help with that application process? Because I know people who have gone years without being able to receive that, both on the VA side and on the civilian side.
I have people that will do that for you.
Yeah, okay.
So you just let me know.
So there are people that help.
Yeah. So what we're trying to do is plan for incapacity. So if you're incapacitated and can't make decisions on your own, then you want to have powers of attorney for finance in place, powers of attorney for healthcare, and if you want someone to have more power,
an overarching.
We're going to want to have a trust that allows that person to have the ability to manage assets on your behalf.
Can you name more than one trustee in the case of an emergency? Okay.
You generally want to. My goal is for people to have 2 to 3 individuals that they trust, and then have a
sequential
trust
order
company in an order, right? And then have a trust company as a final answer. And what happens then is that oftentimes what these individuals will find is they don't have time to manage your estate.
Sure.
So what happens is they'll either work with that trust company as a co-trustee, or they'll actually say, okay, I can't do this, so you trust company manage this for us. So those are the ways to really think about that.
Yeah, because you may be assigned as a trustee, at least in my experience, at 25, and then by the time you are that trustee or have to step into that role, you're 37, you have 3 kids, you can't do that.
You do not have time to be trustee. So and the answer is make sure you have a corporate trustee. And what we also do is we make sure that the successor trustees have the ability to be flexible and appoint successor trustees on their own. So they may have someone that they want to have as a successor trustee or co-trustee with them. They can appoint, again, a corporate trustee, a CPA, someone that's not going to cause too many issues.
Maybe the only skin in the game is a business liability and not emotional.
Right.
Because I imagine that becomes kind of a thing.
Yeah, getting that call at 2 or 3 o'clock in the morning, I need money for, whatever it is, get me out of jail in Tijuana. We want to avoid that for personal reasons. So those are all things that you want to think about during lifetime and while you're alive and well is, what is my risk of needing that? And then if you do end up having that cardiac arrest that takes you out permanently, you want to have a trust that says, I've got a 9-year-old and a 20-year-old. I want to treat them fairly, but I can't treat them equally because the 20-year-old's already out on their own doing their thing. 9-year-old isn't.
Right.
How do I manage that relationship between those two and treat them fairly, even though it's not going to be equal? Because a 9-year-old still has to get through 11 more years of what the 20-year-old has already seen.
Yeah, before he even begins his lifetime.
So that's what we plan for. So we set up a trust that allows you to manage that relationship between those 2 beneficiaries.
So coming in as to get a consultation with you, would 40's not too young?
No. I see clients.
We can
in
look at
their
our steps at least and start saying,
20s
hey,
and
here's how we do it.
30s.
Okay.
Because they have that first child,
Mhm.
right, or second child, and they finally figure out, oh my gosh, I guess I probably need to do something. So oftentimes they'll think that maybe a will-based plan where we have a
That's
will.
usually where most people stop. It's a will.
It is.
And that's, I would be willing to wager that in my generation,
Mhm.
probably only 30% of the people I know even have that.
Right. So what's a will?
Mhm.
Do you know?
My understanding of it is it's a legal document that decides how your estate and the assets that you've accumulated will be divided up upon your death.
Okay, that's great. And so you recognize that a will is not valid unless you die. So you have
Right.
to be dead for it to work. That's number one. Number two, it has to be submitted to and accepted by the probate court in whatever county you're in
Mhm.
Missouri. And it has to be done within 12 months of your passing. If any of those things don't happen, that will is of no value.
So a living will is completely separate too, right? Because if
The
I
living
become
will is a completely different.
incapacitated but still alive, technically,
Right.
then that will is null and void
Well, it's not null and void. It's just not effective yet.
until I'm passed.
Right.
So what if I'm in, this is where you come in, I imagine, right?
Let's
I'm
talk
in
about
long-term care for
let's
3 years.
talk about the will for a little bit more, and
Sure,
then we'll get to
please.
the other stuff. So we're talking about the will.
Okay.
And think about this. How do you own your property right now? Individually?
Yeah.
Do you own anything jointly with anybody?
No.
Okay. What happens if you pass away today? Do you have transfer on death, pay on death? Do you have beneficiary designations for your insurance?
Don't even know the words.
Okay, so these are things that we would have to have conversations about.
Yeah.
And what we would do is we would say, okay, if none of those beneficiary designations exist,
Mhm.
if you don't have transfers on death, pay on death, then we're going to go through the probate process anyway. What the will does is says, these are my instructions, because I don't like what the probate court says.
Mhm.
Right? I don't like what the Missouri legislature said in the probate code. So I would prefer to take control of that. That's what a will does, is take control of things that you own personally that do not have a beneficiary designation, do not have a transfer on death, pay on death, joint ownership, or other alternatives.
Okay. And before we move on from that part, just to clarify this over here. So what you're saying is if an individual does not have a will, each state does have a designated order of operation, so to
Correct.
speak, of that assets.
Correct. That's exactly how you manage that. Okay, and it tells.
And does that include debt that may be incurred with IRS or other things coming out first?
Yeah. Yeah.
So potentially I could have medical debt
Mm-hmm.
or other types of debt, and unless I have a will in place, the state decides where that money goes first, and my children could be left with $7.
There are ways to prevent that.
Yeah, but if you have nothing in place, then that's the state decides?
The state laws
Mhm.
explain how that's done.
Okay.
So your children would still have access to some of the assets.
Okay.
Okay, so those would be excluded from the estate right away for their care.
So they could contest up to a certain point of certain things.
Correct.
Got it.
Right. So that's in the code to protect your children.
Okay.
Okay. After that, it's, there's a list of who gets paid first. Well, obviously, the funeral home gets paid first. Your attorney gets paid.
Right.
Everybody else after that.
Yeah.
Right. So you pay the funeral home, lawyers, and then everybody else.
Okay.
And actually, the IRS and state of Missouri are behind lawyers and the funeral home, which is awesome.
Yeah.
Okay, got to make sure the lawyer gets paid.
Right.
So that's probate, and you want to have a will so you can explain who's going to manage the stuff for you, because otherwise the probate court's going to make that determination.
Okay.
You also want them to know who you want as guardians of your children. In this case, your 9-year-old. Right? Now, is the court going to always go by that? Maybe not, but at least you've told them what you want.
Sure.
Right? So that's part of the reason.
It's kind of like my closing argument after I pass.
Exactly. This is the way I want it. So those are the things that the will does. Okay. Who's the person that's going to manage your estate? It's called the personal representative.
Okay.
Where's your money going to go?
Mm-hmm.
Okay. Who's going to get paid?
Yeah, the order of operation of where your money goes.
Mm-hmm. Who are your beneficiaries going to be?
Okay.
Okay. Now you cannot exclude a spouse completely. Okay, the spouse always has the right to their elective share, which is about 1/3 of your estate. So you can't say, all my money goes to my girlfriend.
Right. Now, is that contingent upon how many dependents you have beyond that? Does it matter? If I have 2 kids or 7 kids, is it still 1/3 to the spouse?
It's still going to be that elective share, that 1/3.
Okay.
Right. You're not going to want to do that to your kids anyway.
Well, sure. I'm just curious because I'm trying to
Yeah.
broad brush things.
Right. So that's how that would work. Okay. So that's the will. That's how that's managed. All right. Now, where a trust comes in is that now you have a set of instructions that don't require the probate court to be an intermediary. Okay. These are your instructions. The person that you name, the trustee, is going to be responsible for managing your assets. None of your personal life, right? Not take you to the ballpark or church, wherever you go, right? It's just monetary.
Right. Okay.
So there's a person called a trustee.
When you say monetary, you're talking about strictly liquid?
No.
Not asset.
Anything
asset.
Any asset.
Got it. Okay.
Anything asset. Kind of like
anything that can be turned into monetary.
Correct.
Right.
Some things are easier than others.
Sure.
But yeah, that's
selling a car is probably a lot different than selling a 300-acre farm.
Yeah.
Yeah.
Pretty much.
Got it.
A lot different.
Yeah.
So any assets that you have can be put in the trust.
Okay.
Okay. And then the trust has a set of instructions. A set of instructions basically reads like this. What happens to my stuff while I'm alive and well? Well, what's the easy part is that it's my stuff. It's my asset. It's my income. I do with it what I want. I put it in, I take it out, I change my trust any way I want to. So you've got full control over everything. And as long as you are the trustee and beneficiary of the trust and still alive and well and not incapacitated, it's what's called a grantor trust. Okay. And that means we use your Social Security number as the tax ID number of the trust. Okay? That's alive and well.
Being that I'm the grantor.
Being that you're the grantor. Okay?
So the same if I was to take out a loan in that sense, that I would be the guarantor.
Well, yeah.
Of that loan.
Correct.
So I'm still responsible for my assets and distribution.
You're still responsible for the income from all sources.
Okay.
Okay? So the next thing to think about is what happens if you're alive but not well. That's incapacity. Okay? You're no longer able to manage your assets yourself. So the first thing we have to do is we have to determine incapacity. There are 3 or 4 ways to determine incapacity. The first is 1 or 2 physicians make a determination. And that's a generic physician. It doesn't have to be your personal physician. It can be a podiatrist, believe it or not. But they can determine incapacity. Once that's done, then they go to the next set of instructions which say, take care of me in a fashion which I become accustomed. So they're just going to be writing checks to make sure you and anybody that's dependent on you is cared for. Okay? So that's incapacity.
Okay.
The other things you're going to need during incapacity are going to be what's called a certificate of trust, which tells everybody in the world who that successor trustee is and where their instructions come from. Okay, it's also going to include a copy of a letter or letters from physicians that have made a determination, or a court order if a court has made a determination as to your incapacity. Okay. Also, it's going to have information about who successor trustees are. It's going to have information about what the trustee's powers are. So those are all things that are going to be available to whoever is acting
on your behalf.
Respect to your your trustee to act with respect to your stuff at financial institutions or wherever.
Okay.
Okay. That's the first thing. Second thing, they're going to need powers of attorney for finance because there are things that are not going to be in your trust, like IRAs, 401ks, 453s, 407s. Right? Not going to be in the trust. You're probably not going to put your car in a trust. We're going to TOD it to the trust. Okay. There are certain types of insurance and annuities that we do not put in the trust. Those things all have to be managed by the attorney-in-fact under powers of attorney.
Okay.
Attorney-in-fact is a fancy word for agent or person making decisions for you. So when I say attorney-in-fact, it doesn't mean me. It means someone that's been appointed by you in the document to manage your stuff, to give them instructions. So this power of attorney for finance is really just a set of instructions. It's a permission slip. Okay, it says these are the things that this person can do on my behalf. The thing about permission slips is that sometimes they can be refused because they're not properly worded. They don't have the exact wording that the company wants. They don't actually talk about a particular asset or thing that this person wants to do. So they can be said, oh, no, that doesn't comply with our requirements. good luck somewhere else. Right?
Okay.
So
they have first right of refusal.
They're great. It's not a first right of refusal. It's a right to say that doesn't work. Now, can you go to court and try and make it sick? Absolutely. And that may be worth doing. Okay. Alternatively, a trust, if you can have the property in it, trust is always a better solution. But again, those things that can't be in a trust or you don't want in a trust, they need to be managed by that financial power.
Okay.
So you've got the financial power. Then we have healthcare directives. And healthcare directives are going to be 4 documents. At least in my office, it's 4 documents. There's a HIPAA release. It gives your decision makers, your trustee under your trust, personal representative under your will, and agents or attorneys in fact, and
to discuss medical issues,
right, and powers of attorney for your healthcare, give them access to protected healthcare information.
Okay.
That's the purpose of that HIPAA release. The second document is going to actually be your healthcare power of attorney. It's going to have instructions that allow your healthcare agent to make decisions about medications, treatments, caregivers, physicians, hospitals, and nursing homes. That's it.
Okay.
Pretty straightforward document. And then there are going to be end-of-life decisions that somebody's going to have to make. It's going to be your family. It's going to be your healthcare agent, whoever it might be. You're going to use what's called a declaration.
Right.
The first one, it's a declaration that says, I'm in a persistent vegetative state. I can't make this decision myself, but the only thing keeping me alive is artificial life support. Please remove that and allow me to die naturally. Okay. Then there's the next one. We call it a medical directive. There are a number of procedures and treatments you may want to have withdrawn or withheld. They're not making a difference in your prognosis. Again, you can't make the decision yourself.
Right,
You're
at this
dying.
point, yeah.
And even though removal, withdrawal, withholding of those procedures or treatments might shorten your life, if they're just not making you feel more comfortable, not changing your prognosis significantly, you may want them withdrawn or withheld. So this is your conversation with your family saying, yeah, I don't want radiation therapy, I don't want chemotherapy,
right,
because it's just not going to make a difference. But it's up to them to make that decision. Okay, so that's really kind of the things during incapacity that are going to be important for your family or your friends to have, so they know what to do and how to do it.
Sure. And
that's all an estate plan really is. It's just your set of instructions saying, this is what I prefer. These are the things I want you to do for me. And
it's a roadmap, but it's not the only way to get there. It
isn't. But the other way to get there is through the probate court. Okay. We prefer not to do that, right?
Right, right.
So that's an estate plan, is that set of documents. And everybody's going to have a different set of documents in my office because everybody's got a different way of thinking about how they want things to work.
Okay. So, and it seems like too, what I would love to do is, we could have a couple of different follow-ups on different areas, but
there's a ton out there.
But to keep this within bite size, so to speak, what are some things that I should look for when I'm choosing the individual or the company to represent me in this way? Are there pitfalls? Are there things that have clients come to you and said, man, we've tried this before and we got burnt because of X, Y, Z, or we didn't look out for this. Right. What are if you could name 3 things, the 3 things that I should be aware of as a consumer and or look out for when choosing?
I think the first thing is to choose an attorney that's been doing this for a while. I've been doing this for almost 30 years.
Okay.
So look for somebody that's been doing it, maybe 15, 20 years.
It takes 11 years to be considered an expert in your field.
Yeah, and I've been doing it a little bit longer than that.
Yeah, you're an expert almost 3 times over, right?
Just about, yeah. So look for that person.
And that's crucial because I think that
right.
just to kind of give a firmer understanding of that from the consumer's standpoint, you've seen things that education can't provide. So you've been in the situation, and it's almost like that field operation standpoint where you've probably been thrown some curveballs that it may never be covered in a general education class or where someone just, I have a degree so I can do this, right? So
it's more than that. I think the most important thing I do is actually have that conversation with the family. So if you sit down with an attorney, and I kind of let the clients make their own decision as to how the process goes. But if that attorney isn't asking you questions about you and your family and getting to know you and understanding what your needs are, then you're probably talking to somebody that's just going to give you one set of
Options.
documents. This is what you get. Who do you want to have in this role?
Right.
Right. So for me, what I'm looking for are what are the things that you want? Because I can do 99.99% of whatever you want, as long as it's not illegal.
You're taking a servant approach rather than
that's
a
what we
compensatory.
Well, that's what we are. We're servants. We're teachers.
Mm-hmm.
Okay. So what I like is for the family to teach me about them.
Sure.
And their loved ones. Do I do it right every time? Goodness, no. My last client, they didn't want to go through that particular process right away. They wanted to know, what it looked like and how much it cost. And so I was happy to do that for them. Okay. My hope is that when we follow up, I get to know them better, get to know their family better. What are they looking for individually?
Mm-hmm.
And if all they're looking for is a set of documents, and it's not important to them that it be their set of documents, that it just be a good
tailored
set of
to their
documents.
needs and their
You can either
desires.
get tailored or you can just get the package.
Right.
And I'm happy to help with that, because there are people that just don't feel comfortable, don't need to have that longer conversation, would prefer just to have a set of documents
And just be done with it.
and be done with it. And I'm okay with that.
Mm-hmm.
We're here to serve everybody and educate them and make sure they make an informed decision.
Okay.
I want them to understand there are other options, but if they still want just documents, I'm absolutely fine with that.
Sure.
They're not going to be the cheapest documents in town. They're not. But they're going to be the best documents you're going to get at that price.
Okay.
The same with our planning. We're not the cheapest planners in town, but you're going to get the best plan for that price.
Quality over quantity.
Mm-hmm.
Yep. Okay.
Yeah, that's my thought process. We spend more time with the client, more time on the planning. So that's probably number 2,
Okay.
is make sure that they're taking an educational approach,
Yeah.
that they're listening to you. And again, we all have bad days, and sometimes I miss that. But my hope is that the clients come back and we can have a longer, good conversation about.
You don't want it to feel like a sterile operative process that's just.
No, and it's truly not. It's their custom plan.
There's nuances. There's emotion. This is family you're talking about.
Yeah,
So there's
and
things
I have
involved.
people that have said, "Can you do this?" I'm like, I don't know. Never done that before. Yeah, I think I can do that.
Yeah.
So we spend a lot of time customizing for clients.
Okay.
Just to make sure that we give them what they want. Now, does it cost a little bit more? Absolutely.
Yeah.
But if you're getting the value, then it's really better than getting just a set of documents that don't do what you wanted.
Sure. A tailored suit looks better than an off-the-rack one.
Correct.
Right? So it depends on how you want to enter this next part, I suppose.
Well, and the instructions should be your instructions, not the lawyer's instructions.
Mm-hmm.
That's the other thing to think about. So, again, somebody with experience, somebody that takes an educational approach and is interested in your family and in you.
Okay.
And then, have appropriate staff that can manage the documents, make sure your attorney is getting things done, because sometimes attorneys get a little bit.
So
busy.
lastly, you would say that the team around the individual
around
is important.
Absolutely. The team around you should be around the attorney and around you, the client.
Yeah.
Should be there.
Excellent.
And those are all things that we have in our practice.
Well, Shawn, I thank you so much for your time. I feel that I've gained a lot more knowledge, certainly starting from scratch, than I had before, and greatly appreciate the insight into what you do and to how you help individuals and families on a level that's not numerical. And so, sometimes the conversations seemed a bit like logical steps, but I think that you put a very good addition of what it means to care about the individual, what it means to serve the individuals, and not make it a mathematical equation. So I really thoroughly enjoyed learning from you on that level. And this is typically something I wouldn't be able to take in the way I did, but the way you explained it and the way that you care about your partners in these things and clients is really quite refreshing. So I thank you for that.
Well, good. Well, that's my hope. Again, my goal is to be educational. Hopefully it's been educational for you and anybody listening to this and watching this.
Yeah, absolutely. And we're going to put all your links and things on the side of this so you can utilize that and people can contact you. But just for the people listening who may not take the time to look, where could I get a hold of you or your company, and how could I inquire about your services?
So first, the best way to do it is just to call our office.
Okay.
We're at 636-233-2017. and you'll talk to either Laura or Kate, and they'll help you get set up with a meeting with me.
Okay.
If you want to learn a little bit more about us, our new website just went up last week. It's www.esteplawfirm.com.
Awesome. Shawn, thank you again so much. I
Thanks,
look forward to seeing you
appreciate
again.
it.